As you know, um, the most important thing is choosing the agent. One of the hard things is for people who've been married 50 or 60 years, and they've always made decisions for each other, and now one of them is failing a little bit and leaving the stove on too many times and forgetting too many things or not sequencing activities very well, and obviously beginning to have some deficits. And you're a loving wife, and you don't want to insult him by not naming him as your agent, because most people say, oh, well, automatically my spouse. Not. There are a whole lot of reasons not be the spouse, but the one I'm talking about now is older people with the beginnings of any kind of failure. So what I've found, and this was from a client, I didn't think this smart thought myself. My client said to me, well, Betsy, we've been married, I think it was 61 years, and if something happened to me and my wife had to make decisions, I think how hard that would be for her. So for me, it's a loving thing that I not name my wife of 60, however many years, as agent, to spare her the difficulty in making a decision. Once I offer that to this couple, it's just as if they're relieved because they had anxieties about naming the spouse. So that, of course, means that they won't just make an advance directive when they're 52 and have it last forever. They will reconsider it regularly in view of what's happening with both of their healths or their marital status or any other number of things. If you have named your spouse and you get a divorce, the spouse part, the naming of the spouse, is automatically revoked, at least in the state of California. All the rest of it remains, but if you have a divorce, you really should do it over again. And yet, interestingly enough, many people had a pretty good marriage, but they just didn't want to stay married. But they still want that person to be their agent. They have to write that in. I know I'm divorced, this is my ex-husband, but I still want him to be my agent. Then that makes it legal.